Everyone, my name is Engineer Vandana Sharma and I welcome you all in this tutorial of PCT. So here we'll learn today about the PCT route, like why to adopt this PCT route. Earlier in our previous session, we actually tried to cover the PCT, what is PCT, so complete elaborated session was uh, discussed, and now in continuation with that particular series, we are here again to understand what all are the advantages of going for PCT route, and then uh, different type of search reports we get, in what format do we get, how to interpret that. So we'll discuss all these things. Before I proceed, again I would like to thank WIPO Academy for providing such a wonderful sources so that we can always go there and refer uh, about PCT and other IPR related content. Thank you. So here we proceed for our next slide. Now let's understand like why to go for PCT route. So what are the advantages to different stakeholders? When I'm talking about the stakeholders, I mean national and regional IP offices, universities, private sector companies, institutions, research institutions, academia, attorneys, and the general public. So these are the different stakeholders involved in filing and going for PCT route for getting a patent to be granted. So what all are the advantages? PCT serves as the foundation of the global patent framework, and it offers a streamlined process for filing patent applications internationally, right? So for national local, we know that the provision is, you can directly go to the regional office and then uh, on that website these days, and then you can file your application there. Within 12 months of time, you can actually make your mind, and then you can proceed uh, further for, if even if you want to go to the international level. So this is what I'm talking about, traditional method. We'll have a comparison also. Now, what all are the advantages of PCT route? When I am, determined enough, like I'm going to the local office or I'm applying to my regional office and I want to enter to the international phase and I want to adopt PCT route. So I will be simultaneously applying for PCT route, and PCT means I want to cover the entire 157 contracting states which are the part of PCT. So, what all are the benefits given to me? It expands your access to global markets. It differs significant expenses and allows for more time to evaluate different patenting strategies. So, basically, when I'm applying for PCT route, it means I'm not only covering my territory, but I'm actually covering the 157 contacting states, right? So, it's the global market is in front of me for my project or process. And then when I'm talking about the expenses, of course, if I'll adopt the traditional method, I have to bear a lot of expenses, but PCT is time saving and money saving both, establishing a solid foundation for making informed patenting choice, and is utilized by leading corporations, academic institutions, and organizations in their pursuit of international patent protection. Now let's understand one by one what it means to be having the access to the global market. A single PCT application holds the same legal significance as a national patent application in all the PCT contracting states. In the absence of the PCT, it would be necessary to submit individual patent applications in each country of interest. So it's a concept which saves your time and money. A significant aspect of the PCT system is its ability to postpone and, in certain instances, reduce the expenses related to obtaining patents in several countries. Beyond the deferral of costs, this system provides you with extra time to enhance or promote your invention, evaluate and investigate different patenting strategies, seek out investors, establish partnerships, and obtain financing, and explore the commercial potential of your invention. Now we know that when we go for national phase, uh, so in that case, in whatever regions you or the countries you want to apply for patent granting, you need to get your patent translated. For example, Germany. For example, UAE. So in UAE also Arabic language. So different zones, the different language, you would be requiring the translation of your documents, and then national fees would be there. And if you are actually applying through agents or attorneys, then you have to bear those expenses or their fees as well, right? So the costs associated with patents that are postponed by the PCT include the translation of the patent application, which consists of highly specialized documents into multiple national languages, official fees imposed by national or regional patent offices, and charges for the services rendered by local patent agent or attorneys. Now let's talk about the PCT versus traditional patent system. So this is a comparison you can easily see. So in traditional method, what will happen? So if suppose I'm an inventor and I want to apply for a patent to be granted for my product or process, or in fact for both. So in that situation, what I'll do, let's say I'm adopting traditional method. So in traditional method, I'll go to the regional office and I'll file a local application, and then within 12 months of time, so I'll have 12 months of time wherein I can actually approach to different regions or countries in the world. So within 12 months time I can actually file applications abroad, fine. So and then it requires a lot of time, and then it requires your money, translation fees, office fees, local agents fees. So you have to bear with all these expenses when you're adopting the traditional method. On other hand, if I'll go and just file my application through PCT route, what would be the action? I'll go to the regional office, I'll file local application, then I'll file PCT application within 12 months of time. And now, after filing my PCT application, I will be getting one report, search report, international search report, and written opinion at the end of the 16th month. By 18th month, my this document, my patent application would be publicized internationally. So international publication will happen, and then the next stage is optional, so it is as per the demand. So then after my application is published, what will I do? I will be actually going ahead and file demand for international preliminary examination, request for supplementary international search report. When I'll get supplementary international search report, then it would be like 28th month, approximately by 28th month I would be getting my supplementary international search report, or side by side, because I have demanded for international preliminary examination report also. So I'll get that international preliminary report on patentability. So from the date, from the date wherein I approached, or I actually applied online on my regional office in India, which we call local application, that would be my priority date, right? So from that priority date till 30th month 30th months of your application, you would be having stipulated time, in fact enough time to actually think, based upon the search results, based upon the opinion provided by the authorities, ISAs, so that you can decide further to proceed, like in which all other countries I would like to go ahead and file my application, where the market potential seems to be good for my product or process. And if it is good, then I can go ahead and I can file to those 5 countries, or maybe 4 countries or 3 countries. So I have enough time to think. Here it's a speed up process, because you just get 12 months time in traditional patent system, but in PCT you have 30 months time, and that too with certain proofs, and then examination reports, search reports. So that is the advantage and difference between PCT versus traditional patent system. Now, once you got the reports, you received your search reports, you received your preliminary international search report, and then other reports, whatever you requested or demanded. Based upon that written opinion by ISAs and that report, search report, you actually have now the strong foundation or basis for patenting decisions. The Patent Cooperation Treaty offers benefits beyond merely deferring expenses. The insights gained during the PCT process regarding the potential patentability of your invention can prove to be immensely beneficial. Such information may lead you to reduce the number of countries in which you pursue national phase entry, or even to forego national phase entry altogether, thereby saving costs. Now let's talk about the international search report and the written opinion of the ISA. So how does the content on the international search report looks like? So you can have a look. So here you can see category is actually mentioned. On top it is written documents considered to be relevant, right? So there are certain categories X, X, Y, A. So X, Y, A, majorly we distinguish the category of the document in these I'll say subscripts X, Y, and A. So, and then after that, after the category is defined, citation of document with indication where appropriate of the relevant passages. So then you would be referring, you'll be citing, like, X category, under X category this is the paper, and what exactly is matching with your particular description or claim in your patent document. Here for example, it is given as category X, and JP 5014535B NCR Corporation, it has filed a particular patent which is actually relevant or having content similar to the content you have in your application. So 28th May 1975, column 4, lines 3 to 27. And relevant to which claims? Relevant to the claim numbers in your document 7 to 9 and 11. Right? So this way you can read this, the content of the international search report. Now let's understand what are the meanings of these categories X, Y, A, what it denotes. So categories of citations are particularly, they are depicting, like, what kind of similarity is there in the referred or cited document and the document which is in the question. So X particularly relevant if taken alone, objection. Lack of novelty or lack of inventive step with one document. Objection could be lack of novelty or lack of inventive step with one document, right? So for a single document, if you are objecting for lack of novelty, and if you want to prove that, these this is the specific area where it loses the novelty or inventive step, so you are referring that document and you put it in the category of X. When we talk about the Y category, it actually depicts particularly the relevant if combined with another Y document. It means, like, this particular Y category is describing that not only the single document which is cited here, but in association with other document also, you can find that these are the similarities which are demonstrated here in XYA category, figure 1, page 3, lines 5 to 7, figure 5, support 36, and then it is relevant to the 1 to 3 claim number, 4, 10, and then 11 and 12 claim number. And then we have this A also. So A depicts technological background, no objection of lack of novelty or inventive step, right? So here O is like non-written or oral, it's like not properly disclosed. And then P is intermediate document published after priority date but before filing date of the application, right? So when you go for a search report, actually the examiners or the agents, they actually check and then cite to the references, right? The papers or any literature which is present there, maybe patents or any literature, non-literature also, and anything which is published, right? Which is in the public domain. So based upon that, these categories are defined. T defines theory or principle underlying the invention, theory or principle underlying the invention. So there the invention principle would be in question. E is earlier patent document but published on or after the filing date. D is cited in the application, like what is there, and then L could be any other reason. So all these are the categories in which the report actually gives you an overview of the prior art or search results, right? So generally it would be in XYA, but in some of the cases you can have other alphabets like E, D, L, or as we discussed. Now, let's talk about the written opinion of ISA, written opinion of the International Searching Authority. So it will have some international application number, which will be distinct for every application, and that will help you to actually help anyone to actually check the stages also, right? So box is given, and then reasoned statement under Rule 43 BIS. So rule is mentioned there with regard to novelty, inventive step, or industrial applicability. We know that these are the three basic criteria to know whether the invention is patentable or not. So first we check for novelty, then we check for inventive step, and then we check for industrial applicability. Citations and explanations supporting such statement are given. So now if you see this report carefully, it states that for novelty it shows claim number 3 to 5, they are, yes, they are novel, but for claim number 16 they are not. Inventive step, if you will just go through the claims 8, 10 and 12, it says that yes, that is having or involving inventive step. But on other hand, claim number 3, 7, 9, 14 to 16, they do not have any inventive step involved in them. Then we have industrial applicability. So claims 3 to 16, they actually uh, prove or reasoned for having some industrial applicability of your product or the document which is in the question, right? So citations and explanations, they would be there. So independent claim, if there is any independent claim also. So what is the criteria which this independent claim is following? Whether this independent claim also fulfills the novelty, inventive step, or industrial capability or not. So basically, patentability assessment of claims would be judged, and then reasoning supporting the assessment would be provided in the written opinion of ISA. Now we know that this step is optional. If you have requested for international preliminary report on patentability, then again you will be getting one report like this, wherein all the claims would be judged on the basis of novelty, inventive step, and industrial applicability. Based upon that, yes, no, the opinion would be shared in the report, and then citations and explanations would be also be provided in the international preliminary report on patentability. Congratulations. Now you have entered to the national phase. So here, following the PCT route, getting all the relevant results or the reports, such reports and even the supplementary reports also, you have secured the place of your patented technology in a few countries or the countries your choice, right? Now you are allowed a period of up to 30 months from the priority date. This is the advantage of adopting PCT route as compared to the traditional way, wherein we were just given 12 months to think and decide, and even to arrange money or the fees also. And in some jurisdictions, even longer to determine the countries in which you wish to pursue patent protection. Throughout this duration, you may have made further advancements to your invention, obtained funding, and explored various avenues for commercialization. Additionally, you will have had the chance to review your international preliminary report on patentability, which includes an assessment of your invention's patentability. The insights gained, along with the patentability information provided by the PCT, will equip you with a solid foundation for making informed decisions regarding entry into the national phase, specifically the countries where you will engage in national procedures to seek the protection, right? So this is the advantage of PCT route. And to initiate this national phase, you must submit any necessary translated application to the relevant national offices and pay the applicable fees. So once you enter the national phase, the examination and approval of your patent will be as per the patent laws and regulations of the respective national office, right? Now the PCT or the WIPO's role ends there. When you have entered to the national phase, after having analysis of your patents potential in that respective country, now you would be in hand of that country's law. As per their law, as per that country's law, you have to go ahead and file your application there, and then it would be decided, or the patent would be granted by that particular country's authorities or the patent office. WIPO will not be interfering. So today that's all from my side. So that's all from my side, and I thank you all for listening me throughout the session. And we'll come up with another subtopic of PCT. Till then, enjoy. If you have any doubts or queries, you can put those doubts and queries in the comment box. Thank you.